This is the second episode on becoming world champion on asset recovery, Hong Kong experience.
Dear colleagues, we're delighted to greet you. My name is Vladimir Kozin, and I am the regional advisor at the UNODC on issues on fighting the corruption in Central Asia. And I'm happy to be a moderator of such a important event. I'd like to remind you that this event is organized or hosted by the network on the asset recovery of the RNWCA and also a regional platform on the facilitated implementation of UN Convention in Central Asia. Dear colleagues, would like to say that we will have a very interesting seminar, and our main experts are the representatives of Independent Commission Against Corruption. That's of Hong Kong, and this Independent Commission Against Corruption, it is a very competent agency, and actually it's historically the first independent body against corruption, which was created. And this agency is a kind of a model for different organizations worldwide, including the Central Asia. We know that in Tajikistan, there is a similar agency. In the Hong Kong is independent. It's directly oversighted by the ministry and of the municipality, and they tackle issues of the corruption and financial crimes. And what is interesting in the context of Hong Kong, that Hong Kong is a part of China, but nevertheless, it has a certain autonomy. As we know, in this context, there is a principal state, two systems, and being part of China, historically, Hong Kong preserves a special political and legal system, including the fact that in Hong Kong, there is the common law applies. Let me speak in English now and introduce our expert.
Dear colleagues, so once again, we have a unique chance today to learn from experience of Hong Kong. And we will hear today both how to recover assets better, but also we will get some important information on how you can get assistance from Hong Kong. And what is important in that regard is that Hong Kong is one of the few jurisdictions that almost completely implemented the requirements of Chapter 5 of the UN Convention Against Corruption on asset recovery. So without further ado, let me quickly introduce our distinguished speakers. We have two speakers today. It's Mr. Sudhir Gulab Kidwani, who has extensive experience in forensic accounting, financial investigations, of over 38 years. He is also the head of the Asset Recovery Office of the ICAC with the specialization on tracing, restraining, and confiscating proceeds of crime. He is recognized by the High Court and District Court of Hong Kong as a forensic accounting expert. He has investigated high-profile cases involving listed companies, banks, and financial institutions, tackling issues such as corruption, fraud, market manipulation, and money laundering. His expertise has been instrumental in shaping international financing crime enforcement strategies with contributions to organizations including FATF, Asia Pacific Group on Money Laundering, Globin Network, and also International Association of Anti-Corruption Authorities, ICAC. Beyond his investigative work, Mr. Gidvani has played a pivotal role in training anti-corruption and law enforcement agencies across Asia, sharing his knowledge to strengthen financial crime prevention efforts. He also holds Bachelor of Commerce degree and professional credentials from fellow chartered accountants, certified anti-money laundering specialist, and certified fraud examiner. His outstanding contributions have been recognized with prestigious accolades, including the Certified Fraud Examiner of the Year Award 2020 by the Association of Certified Fraud Examiners USA and the ICAC Medal for Meritorious Service. His extensive experience, leadership, and commitment on financial integrity continue to have a lasting impact on the global fight against financial crime and corruption. So we are very happy to have Mr. Sud here with us today. And we also have Mr. Lau Hinkit Gavin, who holds Bachelor of Economic and Finance. He has over 15 years of experience as Independent Commission Against Corruption of Hong Kong Special Administrative Region, with a specialization on investigation of corruption, fraud, and financial crimes. He currently works at the Asset Recovery Office of ICAC, also specializing on tracing, restraining, and confiscating proceeds of crime. Mr. Lau also participates in the Hong Kong risk assessment exercise on anti-money laundering and countering the financing of terrorism. So now I am very pleased to give the floor to our distinguished speakers for their presentations. Please, you have the floor.
If I can quote what the Basel Institute of Governance says in relation to why asset recovery, firstly, it is a deterrent effect. Recovering illicit assets helps deter corruption by turning it into a high risk and lower reward activity. Secondly, by convicting the corrupt and recovering stolen assets, countries can also generate funds for development and to strengthen their criminal justice system. The end result is a stronger rule of law, integrity, and trust in government. The Financial Action Task Force, in their recommendation 4, they recommend that countries or jurisdictions should ensure that there are policies and operational frameworks in place that prioritize asset recovery in both domestic and the international context. Countries should have legislative measures to empower authorities to freeze, seize, and confiscate assets linked to criminal activities. Recommendation 4 goes on to state that countries that, whilst recovering assets, we should ensure that freezing or seizing of assets are quickly done so as to prevent dissipation. Tracing and evaluation of assets derived from illicit activities or the equivalent value should be restrained and confiscated. Confiscation can be done through both conviction-based as well as non-conviction-based procedures. We should enforce confiscation orders, including those that are issued abroad. And finally, managing confiscating assets effectively and transparently. If I go on to the UNCAC and Chapter 5 of UNCAC, and the articles under Chapter 5 make reference to returning assets to the country of origin or the rightful owner. It also makes reference to international cooperation, where jurisdictions or countries are expected to cooperate with one another, either through MLA or for extradition or enforcing the foreign orders. Jurisdictions should be allowed to initiate civil action in another jurisdiction to recover assets. Further, asset recovery can be done both through non-conviction as well as conviction-based. For non-conviction basis, either upon the death of the suspect or the absconder of a person, or if there's a flight from the jurisdiction, you should be given the powers to confiscate those assets. And finally, there should be provisions for ascertaining the beneficial ownership of assets so that those assets can then be restrained or confiscated. So what is the strategy for asset recovery? Ideally, we need to trace the assets. Once the assets are traced, we can either seize those assets or restrain those assets so that they're not dissipated. And then upon conviction, or if it's a non-conviction based forfeiture, we then confiscate those assets and finally repatriate those assets to the country who is the rightful owner or the victim of those assets. The challenges that we face on asset recovery broadly are three: tracing of the assets, quantifying the benefit derived by the defendant from the crime that he has committed, and finally, recovery, especially when assets are located in overseas jurisdictions. So this afternoon, our agenda is to cover three main topics. Firstly, the legal framework in Hong Kong. We shall then go through the common challenges in asset recovery, and finally, international cooperation in asset recovery. May I pass on the first part of our agenda, the legal framework in Hong Kong, to my colleague Gavin, who will speak on the legal framework. And after he completes that, I shall deal with the remaining two aspects. Thank you.
Oh, good afternoon, everyone. Today is my pleasure to introduce the asset recovery legal framework in Hong Kong. In Hong Kong, all asset recovery actions are backed up by domestic legislation. Basically, we rely on four legislation to restrain and confiscate proceeds of crime. As you all know, the core function of the ICAC is to investigate corruption and other related financial crimes. So we mainly use the upper two ordinances, which are the Prevention of Bribery Ordinance and the Organized and Serious Crimes Ordinance for our asset recovery actions. Meanwhile, the other two ordinances are used by other law enforcement agencies to deal with proceeds of drugs and terrorism. So before I go into the asset recovery legal framework, let me give you an overview of the two main types of corruption offense in Hong Kong. The first one is solicitation, offering, as acceptance of bribes. These offenses are what we say something for something between the offerer and acceptor. The acceptor gets money, or what we say advantages, from the offerer, and the acceptor do something for or show favor to the offerer. These offenses apply to all public officials and also to the private sector. The second one is unexplained wealth, which apply to public officials only. In case we don't know what the official has done for another, but we have evidence that his lifestyle or assets far exceeds what he should be able to afford when compared to his legitimate income, and he can't give a reasonable explanation, then he will be liable for the offense relating to unexplained wealth. So what kind of asset recovery action can we do for the bribery offense? Firstly, for those who have accepted money to do a corrupt conduct, we can take away the money that we have received if he is convicted. The judge will order the convicted acceptor to pay an amount which is equivalent to the money or advantages that he has accepted to the government if he is a public official. In case the acceptor is working in the private sector, he still has to pay the money to his principal, usually the one who employed them. We call this restitution order. This restitution order is part of the sentence to the convicted person, and this is important as it removes the illicit gain of the corrupt official. The second one is that for a public official who is convicted for an offense of unexplained wealth, we can confiscate from him an amount not exceeding the value of the unexplained properties that was controlled by him. This is what we call confiscation order. The amount confiscated will eventually be paid to the government. This confiscation order for unexplained wealth offense is an effective mechanism to recover the proceeds from the corrupt official. We don't bother to identify what he has gained from criminal activities, but we can simply take away his assets that came from unjustified and unknown source. So now we have power to remove the illicit gain. How can we ensure the corrupt subject will have sufficient assets to satisfy with the restitution and the confiscation order? Okay, by law, we have power to seize and detain anything which we have reason to believe to be evidence of corruption offense. Say, for example, we found a large amount of quantity of cash and valuable items at the residence of the corrupt official. If we have reason to believe that these cash and valuable items are derived from the corruption offense, we can seize them and keep them under the custody of the ICAC. But if the assets controlled by the corrupt official are not material objects, such as the bank saving in his bank account, we have to rely on some other provisional measures to prevent dissipation. To do so, we will apply for a restraining order from the Hong Kong court. The purpose of the restraining order is to restrict the disposal of assets and prevent transfer of assets outside jurisdictions, so as to facilitate our future confiscation or proceeds of crime after the conviction of the corrupt subject. So in Hong Kong, to apply for a restraining order from the court, we have to satisfy the following three conditions. Firstly, proceeding has been instituted against the subject person for an offense. And secondly, the said proceeding has not been concluded. And thirdly, there is reasonable cause to believe that the subject person has benefited from the offense. Well, just now I have mentioned the term proceeding has been instituted as one of the conditions. So what does it exactly mean? In most cases, proceedings are said to have been instituted when the subject person is prosecuted by us. And there will be a criminal proceeding against him, and it's straightforward. Sometimes, if we don't know the whereabouts of the subject person or he has fled to other jurisdiction, we can still restrain his assets if we have obtained a warrant or arrest from the courts. And even in some cases, it is even possible to restrain someone's assets when he is still under our investigation. Say, for example, he has been arrested by the ICAC, but not yet charged because we need time to review the sufficiency of evidence. The restraining order obtained under these circumstances will expire in 6 months or 12 months, depending on the offense and the overall circumstances. That means we have to speed up our investigation and make sure the subject could be charged before the restraining order expires. Okay, now, if we have successfully obtained a restraining order from the court, we can then restrain all realizable property held by the subject person, such as land property, bank saving, cash, vehicle and yacht, etc. This applies to both the property that are located domestically and outside Hong Kong. And most importantly, there is no legal requirement that this asset has to be crime proceeds itself or connected with the criminal activities. Okay, by the law of Hong Kong, realizable property is defined from 3 levels, depending on who the legal owner is. The first category is property held by the subject person, that is the property held in the name of the subject person directly, which is straightforward. And the second one is property which are subject to the effective control of the subject person. For example, if the subject arranged his associate to open a bank account for hiding his corrupt or proceeds, and that the subject person keep the debit card of that bank account. So although the bank account is legally held in the name of the associate, the money in the bank account are indeed controlled by the subject person. Another example is that if the subject person owns a company, then those company assets are said to be controlled by the subject person. And the third category extends to the property held by a person whom the subject person had previously made a gift to. So under what circumstances can we restrain the assets of the gift receiver? So if the subject person has made a gift to another within 6 years before the proceedings were instituted against him, and that the gift is sold or even assets in equivalent value held by the gift receiver are realizable assets, and we can restrain these assets. For example, if the subject person used $1 million to purchase a villa in the name of his wife, then the villa is a gift from the subject person to his wife, and we can restrain the villa. Even the villa is sold before our restraint application, we can still restrain any property in equivalent value held by the wife, say $1 million deposit in her bank account, and that means the property to be restrained need not to be gift itself, as long as the subject person has made gift to another, and we can restrain any assets held by the gift receiver. And this gift concept is very useful in our assets recovery work when the corrupt official make use of their family members to hide the corrupt proceeds. Now, I would like to mention another feature that makes our asset recovery work effective, and this is the disclosure order. If our financial investigation of the subject person cannot identify sufficient assets to cover the amount of crime proceeds of the subject person, we say that this situation is under restraint. We can then require the subject person to disclose his income and assets held in the last 6 years, whether the assets are held domestically or outside jurisdiction. And this requirement not only covers the assets held by the subject person, but also the assets controlled by him. Nonetheless, we cannot use these disclosed information to further our criminal investigation or adduce evidence in the criminal proceedings. What we can do is to include those newly disclosed assets, if any, into the existing restraining order. So now, let me do a quick summary of the previous slide. We say we have an effective framework as we can restrain and confiscate and eventually confiscate not only tainted property that are derived from crime, but also untainted property that the subject person obtained legitimately. And it's also cover property that the subject person are in fact the de facto owner or having a controlling interest, or even the property transfer to his associates. And even the subject person has sent some property outside jurisdiction, the subject person is still legally liable if he disposed those property. Meanwhile, we can then make a request to relevant foreign authorities for obtaining what we call a foreign restraining order in that jurisdiction. So basically, our restraining and confiscation framework in Hong Kong are value-based. It allows us to overcome the obstacle in connecting certain property to a specific criminal offense. And it can reduce the resources spent on financial investigation and then evaluate all available assets broadly based on relevant and timely consideration. This would enable us to focus or prioritize to identify the most suitable assets for restraint, having considered the liquidity, depreciation, and joint interest, and ultimately make assets available for confiscation after the subject person is convicted. So does these provisional restraint measures infringe legitimate rights of the party concerned? To protect their rights, there is a mechanism to vary and discharge a restraining order. Firstly, the subject person can make an application to vary the restraining order, which is normally in case when he has no more money to pay for living expenses or legal expenses. We will agree to release certain amount of restrained assets to meet his living and legal expenses. But that amount released has to be reasonable, and we will not allow Rolls-Royce lifestyle. And if the party concerned cannot reach a consensus on the amount, the court will make a final decision. Secondly, the affected third party or the subject person himself can make an application to discharge the restraining order on the property if they think that the legitimate rights on the property is infringed. The court will consider their legal arguments and all overall circumstances to determine whether the restraining order should be discharged. And sometimes, the victim of crime could make civil action on their own to recover their loss from the subject person directly, and then we would discharge the restraining order because the government would not compete with the victim of crime. And of course, there are many other grounds to discharge the order, say if the restraining order assets had all been released for living and legal expenses of the subject person. But in any event, the court will consider the matter on a case-by-case basis. As I said before, the provisional measure aims to make assets available for confiscation after the subject person is convicted. In Hong Kong, we normally confiscate assets of the subject person if he is convicted in the criminal proceedings. We call that conviction-based confiscation. At that moment, the prosecution will make a confiscation application to recover the proceeds of crime from the convicted person. The judge will determine whether the subject person has benefit from the offense, and if yes, what is the amount of benefit he obtained from the offense. And finally, the judge will make a decision on the amounts to be recovered from the subject person. So besides conviction-based, there are two other circumstances for which conviction could be proceeded without conviction. The first one is for absconder. Say the subject person abscond to evade prosecution or abscond during the trial proceedings. If the subject person has absconded for more than 6 months, we can make an application to the court to confiscate the absconder assets, and we call these procedures as absconder proceedings. In the absconder proceedings, firstly, we have to persuade the court that the subject person is an absconder. If the court is satisfied, we will present the evidence to prove the criminality of the absconder. And the judge will then determine whether the absconder would have been convicted in all likelihood according to the evidence. And if the answer is yes, the court will quantify the amount of benefit and finally decide the assets to be confiscated. Another confiscation without conviction is for deceased person. Sometimes the subject person is prosecuted, but unfortunately, he passed away before the child has been finally determined. In this case, we can still make an application to the court to confiscate the assets of the deceased person. And we call this procedure as deceased proceeding, which is similar to that of the absconder proceedings. Again, the court will determine whether the deceased person would have been convicted in all likelihood, and if yes, the amount of benefit and the assets to be confiscated. So you may realize that no matter in confiscation proceedings, conviction-based, absconder proceeding, or deceased proceedings, we have to quantify the amount of benefit derived by the subject person from the offense. So when quantifying the benefit, or what we say proceeds of crime, we will consider the subject person direct profits, such as the amount of stolen funds, bribe received, and fraudulent earning obtained. But don't forget to take into account of the subject person indirect gains from the offense. They could be appreciation of assets which were purchased by tainted money. The principle behind is to deprive their ill-gotten benefits and in order to show that crime does not pay. Okay, and before I pass the time to Mr. Girani, I would like to mention one more feature of our regime. Confiscation will not be effective if it is not enforceable. It will be meaningless if the subject person does not comply with the order. So when the court make a confiscation order, it will also fix the period for the subject person to pay normally within 6 months, and also fix the default sentence in case the subject person failed to comply with the order. Moreover, the court can appoint an enforcement receiver to sell the subject assets in order to satisfy the confiscation order. All these measures ensure that the court order is enforceable. So now, let me pass the time to Mr. Girani to talk about the practical challenge in asset recovery in Hong Kong.
Thank you, Gavin. So let me just share with you what are the difficulties we face in asset recovery. Now, as Gavin explained earlier, that in Hong Kong, we follow the value-based confiscation, which means we don't necessarily have to confiscate the dirty money or the dirty assets. If there is a clean asset, we can even confiscate that. For example, let's say the suspect has inherited property from his parents, and that particular property was obtained from clean money, and that he had used all his dirty money in gambling or he lost that money, we can then confiscate that property that he inherited from his parents. So we don't really necessarily have to prove a nexus between the assets that we confiscate and the offense that the criminal committed. However, we have faced challenges in court where the defense argue that we have to prove a nexus, but the defense always lose that argument because the law allows us to confiscate such assets. Now, that's domestic law, but then we do have problems when we are trying to restrain assets or confiscate assets in foreign jurisdictions. Depending on the law in the foreign jurisdiction, we have faced challenges where the foreign jurisdiction says that we have to prove a nexus, and the foreign jurisdiction is not willing to restrain or confiscate assets if there is no link to the actual offense. So if it's a domestic asset, we have no problem. If it's an overseas asset, depending on their domestic laws, we may face certain problems. The second challenge that we face is assets that are held by nominees. So then we got to try and prove that the nominee is only holding those assets on behalf of the suspect, and that the suspect or the defendant is the beneficial owner of the asset. So that is what you call, we have to get that evidence to prove the link between the ownership of the asset and the beneficial, to prove the beneficial ownership of the asset. The third issue we face is when assets are gifted away. As Gavin just explained, that assets that are gifted within 6 years prior to the proceedings being instituted are actually considered to be the assets of the defendant. So again, we got to go back to 6 years and see how he disposes assets and whether there are any assets that were gifted away. Fourthly, the most difficult part is quantifying the benefit. For the acceptor of a bribe, it's not too difficult because all we got to do is to see the amount of advantages or bribes that he received and whether there's any indirect benefit that he derived from those assets. For example, if he took a bribe of $1 million, invested in the stock market, and then the value of the shares go up, and then he received dividends on those shares, we can also confiscate the appreciation in the value of the shares and also the dividend that he earned on those shares. However, the problem that we face is to calculate the benefit that the offerer of the bribe got by giving the bribe. So not only do we confiscate from the acceptor of the bribe, we also confiscate the benefit from the offerer. The offerer of the bribe is paying a bribe expecting something in return, whether he's getting a contract, or whether he's getting preferential treatment. We have to quantify the benefit he got from that bribe. And that is the difficult aspect. I shall share with you a bit more detail as we go through the following slides. And the most recent problems that we are facing is piercing the corporate veil. Now, many times we have a director of a company or a shareholder of a company who pays the bribe to get a contract, but then the contract is given in the name of a company. So who actually has benefited? Has the offerer of the bribe, the director, benefited? Has the shareholder benefited? Or has the company itself benefited? Now, according to common law in Hong Kong, a corporate is a separate legal entity. So we have to treat the defendant and the corporate entity as two separate individuals. So I shall come to this as we go through the following slides and explain a bit more detail. So the first point about nexus between assets and offense. Let me give you an example. Tom was a civil servant and he committed a bribery offense. He accepted a bribe of $2 million, and from that bribe money, he lost $1.5 million in gambling. Therefore, he was left with a balance of $0.5 million, which was in his bank account. Now, if we do not have to link his assets to the offense, then we can then see he has another asset of $5 million in real estate. And therefore, his total value of assets is 5.5 million. So the Hong Kong laws permit us to actually confiscate 2 million from his $5.5 million. So this is really, as I said, not a challenge in Hong Kong, but if the same thing applied in a foreign jurisdiction, we may not be able to get the real estate. Let's assume the real estate was in another jurisdiction and we say we want to confiscate that asset. Depending on the laws of the foreign jurisdiction, they may not allow us to confiscate that because they may argue that the 5 million real estate was not derived from the bribe money. Now let's go to another example of assets held by the nominee. Now in this particular case, Sam was convicted for bribery and fraud involving a sum of $30 million. So when we calculated the assets that he has, we were only able to find assets in his name worth $3.2 million. And these were made up of cash, bank accounts, insurance policies, securities, and listed company shares. However, when we did some more digging, we found that Sam is a sole director of a company called ABC, which has a bank account, and in the bank there is $29 million. The next question is then, who owns this company ABC? When we further investigated, we found that the shareholder is a person by the name Peter. Now, who is Peter? Peter is an employee of Sam's ex-wife. So we interview Peter and we find out what Peter said. And he said that he never knew that he was a shareholder of company ABC. He had never heard of the company. He did not know ABC had a bank account. He said he signed the bank documents on the instructions of the ex-wife of the suspect, and that these blank pages were passed on back to Susan. So that is very clear now that Peter is a nominee. So what we then did, we used that evidence and we restrained the bank account of the company, the ABC company, which was actually a BVI incorporated company. So we now then recomputed the assets that we could confiscate from Sam. And now if we include the $29 million in the bank account of ABC, we now can compute his assets to be $32.27 million, which would be sufficient to cover the benefit of $30 million that he derived from the crime. But before we got the restraint order, Sam then changed the authorized signatory of the bank account from himself to Peter. The problem we faced in this particular case was that when the matter went to court for the confiscation proceeding, Yeah, so when we went to court for confiscating the proceeds, Peter refused to testify. I just wish to clarify, Peter was not a resident of Hong Kong. He was living overseas, so he refused to come to Hong Kong, and there was nothing we could do to force him to come to Hong Kong. As I explained earlier, that all the instructions to Peter were given by Susan, there was no evidence that Sam had instructed Peter to be his nominee. So in the absence of Peter giving evidence, it was very difficult for us to prove in court that ABC was under the effective control of Sam. So that was, again, a huge problem, that although we could prove that Peter was the nominee evidentially, but in court without his evidence, we could not proceed any further. So the issues that we face when assets are held by nominee is that we need to identify who is the individual who has beneficial ownership in a particular company. So if a company is incorporated in Hong Kong or elsewhere, and that company is held by a Hong Kong company, then from the Hong Kong company, we need to ascertain who the beneficial owner is. Now, to circumvent this problem, in 2018, laws were passed in Hong Kong, which requires every company that is incorporated in Hong Kong to maintain what is known as a significant controller register. This significant controller register will disclose who the beneficial owner of the company is, or who has significant control in the company. Now, there's a definition of what is significant controller, and basically it means anybody who has more than 25% shareholding or has 25% voting rights or 25% control on the company, his name has to be disclosed in the register. And law enforcement agencies, including the ICAC, the police, the customs, they have the right to inspect this significant controller register to identify the individual that controls the company. The next challenge I spoke about was of assets being gifted away. And I wish to share another example with you of John and Mary, the husband and wife. And John and his associates conspired to manipulate the stock price of listed companies. And in their fraud, they made profits of about $150 million. All these profits were withdrawn by them in cash, and Mary assisted in laundering the crime proceeds. So after, when we restrained their assets, I had computed their assets, and we found out that John has assets of $31.8 million, made up of cash, his bail money, bank balance, shares, properties, and personal property. And Mary had assets of $105.1 million. Now, our assertion was that Mary's assets were gifted by John. And the reason we say that, I shall come to that in a minute. But let me tell you what happened at trial. At trial, John was convicted, but not Mary. Mary was acquitted. So we can only confiscate the assets of a person who has been convicted. So on paper, we could only then confiscate $31.8 million. But our argument was that the assets that were in the name of his wife, Mary, were gifted by John to Mary. And therefore, those assets should be counted as part of John's assets. Now, we looked at the history of Mary. Mary was a solicitor, and we looked from the tax records that she had earned only $95,000 in the past 6 years. Now, if she earned $95,000 in 6 years, how could she then have $105 million in her account? So, number one, there must be an inference that John had given a gift to Mary of $105 million in assets. Secondly, Gavin had explained to you that we can ask the defendants to give us a disclosure of their income for the last 6 years and all the assets that they have. And Mary disclosed in her affirmation of disclosure that she was given cash by John, basically for household expenses and for maintaining the children's education. The properties that she held, she admitted, were given by John. The funds were provided by John. The bank deposit, she said, originated from sale proceeds of 2 properties, one of which was gifted by John, and one, she said, was purchased before the charge period. But the fact that it was purchased before the charge period is irrelevant because in Hong Kong, as I said, we can confiscate even clean assets. So even though the property was purchased not from the crime proceeds, we can still confiscate that. So that argument did not hold. So when we went to court, despite the fact that Mary was acquitted, we then, claimed that the total assets that John and Mary had were $31.8 million and $105 million, and that we are entitled to confiscate the entire sum. Eventually, the court passed an order for us to confiscate $111 million, and we got a confiscation order to that amount. And the judge also passed the order that if they do not pay the sum within 6 months, then John has to go to prison for a further 9 years, in addition to the period he got for his criminal offense. So that is known as the default sentence. In the event that the criminal does not pay the confiscation amount, then he goes for an additional term of imprisonment. So what are the challenges then we face in tracing assets? Number one are gatekeepers. I mean, criminals could use solicitors, accountants, or corporate service providers to assist them in hiding their assets. The second is, of course, proving the beneficial ownership due to insufficient transparency. The third is shell corporations, where you have nominee directors and shareholders. Then you have BVI or offshore companies such as BVI and Cayman Island companies, where it gets difficult for us to track down who the beneficial owners are. And now, in view of the technology advancement, money can be transmitted by just pressing a button on the mouse. You just click the mouse and money can go from your bank account to anywhere in the world. So the free and quick capital flow prohibits us from taking quick action. And virtual assets is the biggest challenge that has now virtually come up, because it's difficult again for us to try and identify virtual assets and then further to try and restrain and confiscate those assets. So these are the new challenges that we face in tracing assets. And if I now move on to the challenges in quantifying assets, and as I said, the challenges that we face normally are in relation to the benefits derived by the offerer of the bribe. Now let's take this case example, that an offerer gives a bribe of $3 million to an acceptor. The acceptor takes the bribe and gives it to his wife. The wife then gives the $3 million to a professional money launderer. The professional money launderer will keep $0.1 million as his fees, and then he will launder the $2.9 million on behalf of the acceptor. So what is the benefit here? The law in Hong Kong says proceeds of crime refers only to money or property which represents an economic benefit gained by the criminals in connection with the commission of the predicate offense. So before a confiscation order can be made against such a person, they must also be shown to have economically benefited from those proceeds. So taking the example that we just went through, the acceptor received $3 million. So of course, his benefit is $3 million, and we can confiscate $3 million from the acceptor. Whereas the wife, who helped her husband in laundering the crime proceeds, did not benefit from the crime because she only passed on the money to the professional money laundering. So all we can do for the wife is to charge her with the offense of money laundering, but we cannot confiscate anything from her. As far as the professional money launderer is concerned, yes, he received the $3 million from the wife of the acceptor, and then he laundered $2.9 million, keeping $0.1 million for himself as his fees. So for the money launderer, we can then confiscate $0.1 million because that is his economic benefit. So the total amount we can then, in this scenario, confiscate is $3.1 million. However, we have not looked at the benefit derived by the offerer. What did the offerer benefit by paying $3 million to the acceptor? To explain this scenario, let me now give you another example. Let us say that a director of a construction company is the offerer, and he offers $3 million bribe to the head of an infrastructure department so that he can get a contract of $1 billion to build a certain infrastructure. Let's say a bridge on this road. Now, what is the benefit of the director of the construction company? Is it $3 million bribe that he gave? Is that the benefit? Or is the benefit the entire sum of $1 billion that was the amount received on the contract for building the bridge? Or is it the gross profit that he derived after for the whole contract? Or is it the net profit? What about other pecuniary advantages that he derived from getting this contract? Let's look at this income statement of the company. Now, we know the contract sum for building the bridge was $1 million. Let's assume the cost of production, which is the cost of, say, materials, cement, and steel that is used for building the bridge, and then the cost of labor for paying the employees for that he employed for building the bridge. All that came to $600,000, leaving a gross profit of $400,000. Then, after that, you minus $200,000 being administrative expenses, such as salaries for administrative staff, such as rent, such as entertainment, and leaving a net profit of $200,000. So now, when we go to court, we have three main figures here. Is it 1 million? Is it 400,000 gross profit? Is it 200,000 net profit? As I said, we have to look at what is the economic benefit. Now, from the cost of production, we have to remove the bribe amount because that's not a legitimate expense. And then from the other administrative expenses, we got to see what other expenses, such as entertainment, business registration fees, directors' remuneration, rental expenses, what are relevant to the contract. So, as I said, bribe is not an economic benefit. If we take the whole contract sum of $1 billion, it is disproportionate to do so. We can look at the gross profit. We can look at the net profit. We should also look at the pecuniary advantage of obtaining a market share, excluding competitors, and saving costs on proper tender preparation. Those are the pecuniary advantages which are difficult to quantify. The other problem that comes up then is corporate veil. In this particular case, let's say the contract for building the bridge was given to the defendant's company. And as I said, in common law in Hong Kong, a limited company is a separate legal entity from the director and shareholder of the company. So we say the contract is given to the construction company. The payment of bribe was made by the construction company. The sum of $1 billion was released to the construction company. The construction company runs a legitimate business apart from this constructing the bridge. And there was no deliberate evasion of liability by interposing the construction company. So if that's the case, the bribe was given by the defendant, and we are saying the company has benefited from the bribe. So what do we look at? Does the defendant control the company? What is the extent of his shareholding? What is the relationship between the defendant and the company? Whether the defendant's corrupt act and the steps taken by the company in advancing those corrupt acts can be linked? And whether the defendant and the company are acting together in the corrupt act? Can we say that the defendant's company is equivalent to the company's benefit is equivalent to the defendant's benefit? So all these challenges come up in court, for which we have to find an answer. So could we also say that the benefit of the defendant is the remuneration he got from the company as a result of getting this contract? Or are we just going to take a proportionate amount of his shareholding? Let's assume that the defendant has 50% share in the company. Then do we then calculate 50% of the profit? and say that's his benefit? Or is it the best way forward is to not only prosecute the director who paid the bribe, but we also prosecute the company that got the contract? Because by prosecuting the company in addition to the director, then it is very easy for us then to what you call confiscate the proceeds or the benefit derived by the company, because it is very clear that the company benefited by getting the contract. So these are matters for which we all have to consider, and it depends upon the laws in your individual countries, whether you have the laws for also what you call prosecuting the company in addition to the defendant or the individual. Let me move to the third agenda item for this afternoon, being cooperation in asset recovery. Now, why is international cooperation important? It is important because many times we find assets are hidden abroad. The legal system in another country is different from our system. We need to identify who is the rightful owner of that property. We have to ensure that there is no safe haven where you can hide your assets. And finally, it must be a deterrent, because if there is internal cooperation, the assets will be returned to the country that should get the money back. So then, therefore, the criminal cannot hide his assets elsewhere. So international cooperation is a must, and we can cooperate with each other basically under different mechanisms. One mechanism could be a bilateral agreement between the two countries, and we can then cooperate through the MLA system. The other way being a multilateral agreements, either the UNCAC or UNTOC. The other way of cooperating is through an undertaking of reciprocity. So even if there's no bilateral agreement or no multilateral agreement between the two countries, but if we undertake of reciprocity where we agree to help each other, we could then do so. And finally, through an informal agreement of agency to agency. Now, if I look at UNCAC, now UNCAC, Hong Kong being part of the People's Republic of China, so it was the People's Republic of China that signed the convention in December 2003, and it then became effective as far as China is concerned in 2006. So following the implementation of UNCAC, we have Article 153 of the Basic Law of Hong Kong, which says that this convention is applicable to the Hong Kong Special Administrative Region and is therefore implemented through our local legislation. Our local legislation in relation to this UNCAC is the Mutual Legal Assistance in Criminal Matters Corruption Order. It falls under Chapter 525W of the laws of Hong Kong. That said, Hong Kong then can receive and execute MLA requests based on UNCAC. And then we can return assets in accordance with Article 57 of the Convention. So if any one of you would like to use this mechanism, Hong Kong will oblige and Hong Kong will assist in returning your assets. Now, when a request is made to Hong Kong, there are certain conditions that need to be met. Firstly, of dual criminality is a mandatory requirement. Secondly, there must be at least 24 months imprisonment in the requesting jurisdiction for that offense for which you are now seeking the return of the assets. And then it must be applicable to foreign proceedings which are either criminal or civil in matter. So even though if you want to make a civil recovery, we can do so even if it's a civil action in the foreign jurisdiction. Now, for restraining the assets or prohibiting the dealing in property, the Hong Kong court will make a restraint order if it is satisfied that the proceedings have been instituted in the place outside Hong Kong, the proceedings have not been concluded, and that either an external confiscation order has been made or there are reasonable grounds for believing that an external confiscation order may be made. Because we believe that a restraint order is made with a view for future confiscation. So if there are reasonable grounds that a confiscation order will be made, the restraint order can go ahead. Now, for registering and enforcing an external confiscation order, again, there must be certain conditions which we have to satisfy the Hong Kong court, namely that the external confiscation order is enforced and is not subject to appeal. Further, the subject person concerned received notice of the proceedings and had the opportunity of defending those proceedings. The purpose of the external confiscation order is to recover payments or rewards received in connection with the external serious offense or their value, or to recover the property derived or realized from payments or rewards received in connection with the external serious offense or value of such property. And finally, to deprive a person of a pecuniary advantage obtained in connection with the external serious offense. Now, we spoke about the MLA, the mutual legal assistance, but I think for all those who have adopted the MLA approach will agree with me that the MLA is a very slow process, and it takes a long time for the MLA process to actually take into effect. So, we can then, before we embark upon the MLA process, we can, of course, use the informal assistance. Although the MLA is a slow-moving process, the informal assistance is less formal, and it is a direct communication between agencies or the financial investigation units in the country. It is a precursor to formal MLA request for us to share information and the requirements that are necessary for making the formal request. Now, for example, if you want to know whether in Hong Kong a particular property exists in relation to a defendant in your country, we can then make inquiries in an informal basis on your behalf and then provide you with that information regarding the existence of the asset in Hong Kong, based on which you can go ahead and then make your MLA request. However, if you start directly with an MLA request asking whether the asset is here, to get a reply from the MLA request will take a long time, and then for you to actually execute a restraint order will take much longer time. So it's always better to use the informal assistance first and then move on with the MLA request. Of course, with the agency-to-agency request, you then build the trust and relationship between the two agencies. And now with us being a member of the Globee network, it's another avenue by which we can get information on assets in foreign jurisdictions. Now, a foreign country may decide to institute civil proceedings rather than go through the MLA request, which may be actually an expedient way of doing it, and therefore Hong Kong allows the foreign jurisdiction to institute private civil proceedings in Hong Kong. However, if you decide to do so, the Hong Kong government will not be involved in the legal proceedings, and nor will we represent the foreign government or party seeking the recovery of assets. It is then the responsibility of the requesting party to instruct the Hong Kong law firms to assist them in the recovery of assets. Now, actually, we have had instances where a foreign jurisdiction has approached Hong Kong and used what you call private lawyers to recover their assets. And the reason they did that is because they did not want to wait for the conviction of the defendant in their foreign country before getting those assets. So they got the assets actually even before they got the conviction in their country of the defendant. If they had adopted the MLA request, then we would have to wait for the conviction and then process the request through the MLA channels, which would have taken a much longer time. Now, repatriation of recovered assets. The proceeds of confiscated assets shall be retained by the requesting party unless otherwise agreed. Now, sharing of recovered assets, basically, this is decided by the Department of Justice in Hong Kong, because they are the central authority on dealing with recovery of sharing of assets. So they decide whether there's going to be any sharing on a case-by-case basis. However, under ICAC, there's an obligation to repatriate assets in full in cases where the victims of fraud are to be compensated, and also in corruption cases. And once again, as I said, if it's a bilateral agreement, the basis of sharing is decided either based on the bilateral agreement or the multilateral agreement. So that completes what we have to say this afternoon. We are happy to take any questions that you have for us.
Thank you so much, Mr. Gidwani, Mr. Lau. It was very informative, and I think we are all very impressed with the amount of information you have been able to cover. So it was very interesting, and thanks again for your presentations. We actually do have questions from the audience, and I'll read them out in a minute. The first question is from Mr. Slavomir Redo. And with your permission, maybe I'll give a short answer to this because it's about the Hong Kong ICAC model in the context of Central Asia, and what is the interaction between anti-corruption agencies in Central Asia and Hong Kong. So I will just briefly comment on that. As I have mentioned in the beginning, of course, ICAC historically was the first real anti-corruption agency which combines both prevention and law enforcement. And indeed, it is a very attractive model for many anti-corruption institutions, including Central Asia. So until recently, we had anti-corruption agency in Kazakhstan, which was based on this model, and now we also have the agency in Tajikistan that uses the same approach, basically combining law enforcement and prevention and comprehensively cover all the spectrum of anti-corruption matters. And what is interesting is that recently we also have facilitated the cooperation between ICAC and Central Asian anti-corruption institutions. So we have the fast-tracking UNCAC platform. We have had 2 regional events. In both events, ICAC was actually participating. It generated a lot of interest in the region, and I think also there were some bilateral MOUs that were concluded between the Central Asian agencies and ICAC. So I hope that cooperation will continue, and then there will be more exchanges and more mutual learning. And now I think I'll give the following questions to you. They are more relevant to our direct topic today. So there was a question from Mr. Talant Mamirov, who asked how the process of parallel financial investigations is organized in Hong Kong Special Administrative Region and by ICAC. And also there were technical questions from Mr. Shuhrat Homidov. So first question is, how do you assess the value of assets? And I think that is relevant in the context of illicit enrichment, because corrupt officials, they can declare assets, but they can also artificially depreciate their value vis-a-vis the market value. So do you have a special mechanism for determining the actual value of the assets when you apply your illicit enrichment and other forfeiture mechanisms? And then
I think,
yes, so you can
no, go ahead. Sorry.
Yes. Mm-hmm.
I think for illicit enrichment, we in Hong Kong refer to that as a Section 10 of the Prevention of Bribery Ordinance. So basically, if a public official is maintaining a standard of living above his official emoluments, then of course we says illicit enrichment. Now, valuing the assets for forfeiture and confiscation is totally different from valuing the assets for calculating illicit enrichment. Let me first go to confiscation, asset recovery, because that's the topic for today. When we go for confiscation of assets, we look at the value at the time of confiscation. Now, let us assume that the defendant purchased property for $5 million, and he purchased this property five years ago. So, and today the value of the property has gone up to say $7 million. So it's gone up by 2 million. So we get a valuation done from a government agency or government department called the Rating and Valuation Department. So we give them the address and we say, can you tell us what is the current value of that property? So when we go to confiscate, we'll have to look at, we can only confiscate up to the value of the benefit that he derived from the crime. So the rating and valuation department will tell us that, look, the property value today is $7 million. So we will take that value. If he has shares, which are also, the value changes every day. So the value today of the shares can be, it's an open public document. You go to the stock exchange from their website, we can see what is the value of those shares. If it's an insurance policy, we write to the insurance company and say, tell us what is the current value of the insurance. So depending on the type of the asset, I mean, for anything lying in the bank, we just ask the bank, what is the value? What is the amount of assets that he has in your bank? They'll tell us the value. So depending on the type of assets, we go to various institutions or departments and we calculate what is his value as at the date of confiscation. And then we compare that value with the total benefit that he has derived, and then confiscate assets accordingly. Have I answered your question, or is there anything else you need on this?
I think that was a very detailed answer. And just another aspect of illicit enrichment,
Yes.
would you be able also to cover that? Because I think the question was, for example, if the official declares assets, but he artificially lists lower price, which is not corresponding to the market. So
that's fair enough.
Yes. Mm-hmm.
So going back again to that question is, let's say the individual purchased property 5 years ago. He actually purchased for $5 million, and then he declares that he purchased for $3 million. So he under declares what he purchased. So once again, we can go back again for that property to the rating and valuation department and tell us what was the value of the property 5 years before or 5 years ago. And they will, on that particular date, suppose he says, I purchased the property on, say, 15th of August, 2017. I can ask them to tell us what was the market value at that particular time. And then we can get a reasonable value as to what the value was. Similarly, if he's saying shares, we can go back. We have records going back from the stock market to see what was the value of the shares. So it's quite easy to go back and see what the value was. It's not difficult.
Mm-hmm. Okay, excellent. And then there are also kind of a relevant question about confiscation mechanisms and certain legal aspects. So there was a specific question whether would you maybe you experience that scenario, but in case you would encounter it, what happens if a culprit basically takes a loan and then he returns a loan with illicit proceeds? Can you confiscate those illicit proceeds?
A corporate takes a loan and then returns the loan with illicit proceeds.
Exactly.
Okay, we can. We can, provided the corporate has been charged with the criminal offense.
Mm-hmm.
So for us to confiscate, we need a criminal conviction, or we need proceedings to be instituted before we can confiscate. So if that corporate has actually used illegal proceeds, then I would then presume that they are guilty of money laundering if they're using what you call illicit proceeds to repay. And then if that corporate is charged with money laundering, then yes, we can confiscate. But we need that corporate to have proceedings against that before we can take any action for confiscation.
Mm-hmm. Okay, thank you so much. Then there was also another question about institutional arrangements. So you explained that you are heading the anti-corruption office, asset recovery office within ICAC. And then there was a question, are there any other specialized bodies in charge of asset recovery in Hong Kong besides your office? And what are their powers?
Okay, no, let me say this. Can I just give you a bit of history?
Mm-hmm.
I want to go back to 2008. In 2008, Hong Kong went through a mutual evaluation by the Financial Action Task Force. Hong Kong has the laws for confiscation and restraining assets or crime proceeds. But we were criticized by the FATF saying that, yes, you do have the laws, but we do not see you're very effective. The reason being is that investigators in general, they thought that once they, complete the criminal case and the defendant goes to prison, then the case is over. They were not really very enthusiastic in recovering crime proceeds. And that is what Hong Kong was criticized way back in 2008. So then Hong Kong took that on board and said, all right, we shall now take a concerted effort to try and also recover assets. ICAC was the first law enforcement agency in Hong Kong that set up an asset recovery office. So my role and the role of my team is basically to restrain and confiscate assets to take over the case of recovering assets after the criminal case is over, so that the frontline investigator then can carry on investigating his other criminal cases. And we just, concentrate on asset recovery. Other departments like the police, for example, they do not have an asset recovery office. Over there, they have their own case officer will continue with asset recovery, efforts. So we are, I believe, the only law enforcement agency in Hong Kong that has asset recovery. I'm not saying it's not being done by the other agencies. They're also doing it, but they're doing it internally by their own, investigators. They don't have a specialized unit. So Hong Kong has actually done very well since 2008. Our figures and our statistics show that we have made a lot of importance on asset recovery. And during the next mutual evaluation in 2018, we were appreciated for the efforts that we have taken on asset recovery. So Hong Kong as a whole is doing well. ICAC has decided to have a specialized unit, and that's why we have an asset recovery office.
Thank you so much. In Hong Kong, we now have a centralized asset recovery office only in ICAC. And for other law enforcement agencies, they don't have such. Because I think the origin of this question is also because in some countries you have kind of holistic asset recovery offices, so to say, which are separate entities, but they handling all the criminal proceeds. So not just corruption proceeds, but also proceeds coming from organized crime, drug trafficking, and so on and so forth. But in Hong Kong, we have the Asset Recovery Office specifically based in the Independent Commission Against Corruption. That is very clear.
Sorry, can I add one question? One more point is that the Department of Justice has a unit on asset recovery. They call it the Proceeds of Crime Unit. So we have a Proceeds of Crime Unit in the Department of Justice that deals only with asset recovery. Now, one of the main reasons for this is that I think Gavin explained earlier, that we can compel a defendant to make disclosure of his assets. Now, defendants actually have the right of silence. They need not answer any question. But because of the laws that we have here on asset recovery, we can force a defendant to disclose all his assets that he held during the last 6 years and all his income. By doing that, any asset that we were not aware of previously, we can then restrain and then confiscate. However, the information given by the defendant should not be disclosed to the investigator investigating the criminal offense, because he cannot use that information in his criminal trial. So for this particular reason, it makes sense to bifurcate. There is actually a wall between us and the frontline investigator. I will not tell the criminal investigator what I know about the defendant's assets. However, I will expect him to tell me everything he knows about the criminal trial. Similarly, in the Department of Justice, this wall exists between the Proceeds of Crime Unit and the advising counsel advising on the criminal aspect. So we have the ICAC having this specialized unit, and we have the Department of Justice also having the Proceeds of Crime Unit.
Okay, thank you so much. That was an important clarification. Then there is also another question about the Hong Kong institutional / legal system for processing incoming asset recovery requests. So what is the authority for receiving mutual legal assistance requests on asset recovery in Hong Kong?
Yeah, the central authority for receiving requests is the Department of Justice. And within the Department of Justice, they have a unit called the MLA unit, or the Mutual Legal Assistance Unit. So any request you need to address it directly to the MLA unit of the Department of Justice. They will go through your request. They will make sure it meets all the requirements. And once that is satisfied, then the ICAC or the police, depending on the nature of request, or the customs, they will assist the Department of Justice in enforcing the restraint and confiscation.
Okay, that is very clear. And I believe that would also be applicable to potential asset sharing agreements, because the question also mentioned that aspect. So going back to a relevant question of illicit enrichment, because it's related to asset declarations, there was also a generic question about the structure in Hong Kong. So the question was whether only public officials are required to submit asset declarations, or it is applicable to all citizens.
No, it's only public officials in Hong Kong.
Okay, thank you so much. And then also going back to the question of parallel financial investigations.
Yes.
So how is that process organized in your office or in ICAC?
So it really depends. I mean, if there is an offense having been committed in Hong Kong and also in the foreign jurisdiction, then of course we could have a parallel investigation between the two jurisdictions. But if the offense is only committed in the foreign jurisdiction and you need our assistance in restraint and confiscation or any other assistance, for example, getting witnesses or getting some documents, then of course there's no parallel investigation. Then we are just assisting the foreign jurisdiction in getting their evidence or in restraining assets. It's by case basis. I mean, if sometimes you have an offense being simultaneously, or not simultaneously, being covered in two jurisdictions, and if we feel that yes, we can prosecute that offense in Hong Kong, then yes, then we are talking of a parallel investigation.
Okay. So let me clarify here, because what I think is meant in this question with regard to parallel investigations is a parallel criminal and financial investigation, because like very often, and I know that is particularly relevant for Central Asia, investigators, they focus on criminal cases.
Yes.
And then they collect criminal evidence and maybe not paying that much attention and effort to financial investigation part of the case. So, and what is also, I think, recommended in many FATF reviews and also in some of the UNCAC implementation reviews is basically to initiate from the very beginning in parallel criminal case investigation and financial investigation. And for some countries and some agencies, it is a challenge how to organize this work, because usually, I mean, again, depending on the nation, but very often investigators are trained in criminal procedures. They know how to collect criminal evidence, but they do not know that much about forensics, financial investigations, and so on. So how is that process organized in your agency?
Okay. Let's say in ICAC, we have another specialized unit called the Forensic Accounting Group. So if it's anything complex on financial investigation, for example, illicit enrichment, where we got to look at the financial records of the suspect for the last 7 years, then we pass it on to the Forensic Accounting Group. We have specialists there, forensic accountants, who will do it for us. But coming back to your question, see, in Hong Kong, banks, because the bank secrecy laws, banks will only provide us information or documents based on a warrant. So we need to get either a warrant from the court, or we need an authorization from our commissioner who authorizes to get certain documents from the banks. Now, that can only happen if we are running a criminal investigation ourselves. If the request is from a foreign jurisdiction for us to get documents from a bank, then we need to go through the MLA request and get what is known as a production order. So we are getting then documents from the bank to what you call supply those documents to the foreign jurisdiction for them to conduct their own financial investigation, not us. So only if there's a parallel investigation, as I said earlier, that if we open a criminal investigation in Hong Kong, and we will only open a criminal investigation in Hong Kong if the crime has also been committed in Hong Kong, then we can use our powers to do the financial investigation. Otherwise, we can only get documents from the bank based on a production order and supply those documents to you.
Okay, very good. So I think we are approaching the end of our webinar. We still have some questions which remain. So maybe I'll take one question.
Yes.
And the question is about the liability of legal persons in Hong Kong. So do you have liability of companies of legal persons for money laundering? And what kind of liability is it? Is it criminal or administrative? And do you often also prosecuting or investigating such cases?
Yes, yes. We can what you call prosecute corporates for money laundering. Yes, they would be liable for money laundering. If we prosecute and if we get a conviction, then of course we can confiscate the benefit derived from money laundering. So as I said, for us, for criminal action, we need a prosecution for us to take any action for forfeiture or restraint. Without criminal action, at least the ICAC cannot.
And that would be criminal offense.
There could be civil remedies. Sorry?
And that would be criminal liability.
Yes, criminal liability, yes. There is criminal liability provided Department of Justice agrees that there is sufficient evidence for prosecuting the corporate. What generally happens in Hong Kong is that in most cases, we prosecute an individual, the man behind the company who's actually the director or the shareholder who's involved in the acts. That seems an easy thing to do. But yes, we can prosecute corporates, provided there is sufficient evidence to prosecute the corporate as well.
Okay, yeah, thank you so much. I think that question is also important for the region because in most of the countries, it is not legally possible to prosecute a corporate for an offense, including money laundering, but some countries have administrative liability. So it's a bit different, but it is a relevant question, and I think it's also one of the FATF recommendations as well. Okay, so actually, if we have, I think, 1 minute, we could also go to the last remaining questions, if you could bear with us. And that question was about beneficial ownership information.
Yes.
So is there any system in Hong Kong for the verification of such information before and after companies are registered?
Yes, there is actually. As I mentioned earlier, that Hong Kong companies have to maintain a significant controllers register. The responsibility is on the company's registry to verify the accuracy, but they don't verify for all the companies. They have a sample they select, and they look into that sample and see whether the information disclosed is accurate or not. So, we don't go ahead, we don't do it unless we suspect that the information is not. See, based on the evidence that we collect, if we feel that the information we get from the significant controller register seems to be inaccurate, then of course we will dig deep and try and find the real beneficial owner. But the onus is on the company registry to do a sample check on the companies that file these registers.
Thank you so much. Again, we are very grateful for your time. It was great to learn from the ICAC experience. That is not our last encounter. So we're gonna have more webinars with your support, and I'm sure we will learn a lot of new practical things that hopefully can also be applied in the region. So I would like to thank you on behalf of WCA regional platform and also UNODC for these excellent presentations. Colleagues, уважаемые коллеги, участники наших вебинаров. Напоминаю, что через 2 недели у нас будет очередной вебинар, посвященный вопросам распоряжения возвращенными активами, и мы будем обсуждать опыт Узбекистана в этой области, и более конкретно это специальный фонд Ишонч, который был создан в Узбекистане для того, чтобы обеспечить надлежащее распоряжение активами, возвращенными в Узбекистан из Швейцарии. Поэтому, коллеги, большое спасибо, благодарим вас за участие, за ваши вопросы. Надеемся, что это мероприятие было для вас полезным, интересным, и остаемся с вами на связи. Всего доброго и спасибо.
Спасибо, коллеги.
Thank you. And on behalf of the ICAC, thank you for giving us the opportunity to share our experience. And we appreciate your cooperation. Thank you again. Thank you.
Thank you. Bye-bye. All the best.